friends, we're very happily at Dunnottar Castle today with Common Law Assent. That's our campaign, Common Law Assent, your country needs you. So our campaign is about being responsible and law-abiding ourselves. We stand under Article 61 of the Magna Carta, 1215, and if you read that, it will explain a lot about what it means to stand under that law. And one of the things is to compel other people to stand under law alongside us. And that we all have a duty to stand under the law. So that means, and it says for the whole realm. So that's the whole Commonwealth. So everybody brings something to the table, that kind of thing. Nobody, it's not like a one person, man or woman show. We all have something to contribute to that. So if we try to do things all on our own, it's not going to work. It needs everybody to take responsibility, and that is our personal liability, how I understand it, because if we don't take action to stand under law, and evidentially at this time, according to that, then that's known as silent acquiescence. So anyone who hasn't withdrawn allegiance, say, from what's carrying on in our names, then that's called silent acquiescence. So that's taken as consent. So basically what we do with our campaigning is we are removing our silent acquiescence, we're taking responsibility, owning and declaring our responsibility, our sovereignty, and upholding our rights. So I've been reading the Layman's Guide to the English Constitution by Albert Burgess, and it's quite long. So we got to the point where we talked about sedition and treason. We'd covered the Declaration of Rights, the Stuart Kings, before that the Tudors. We'd talked about laws. You can actually follow the whole of our series, and I'm just going to carry on. We're at the Finance Bill 1909 and Parliament Act 1911. Such a situation occurred in 1910, saying that Parliament, there's a major crime of sedition happening. That was in the last chapter. So such a situation occurred in 1910. The Asquith government attempted to put through a finance bill. The Lords rejected the bill because it imposed too high a tax burden on the subjects. So they were subverting the makeup of Parliament. That's what it was talking about. The Lords, particularly, they rejected, subverting and dissolving the power of the House of Lords back then. So the Lords rejected the bill, but because they thought it wouldn't be very good for the subject. Isn't it beautiful here? We're in Scotland. And they believed that they had no right to amend a money bill after the seditious and illegal 1667 ruling by the House of Commons. Asquith went to the Lords and told them he was putting forward a bill that would limit their authority to reject bills. If they did not pass this bill, he proposed to put 500 new peers into the Lords, and they would vote for the closure of the Lords. The Lords gave their consent to the Parliament Act 1911, but under duress. The bill was presented to King Edward VII, who refused royal assent on the grounds that it removed a protection given to his subjects by the Constitution. King Edward told Asquith he would have to ask the country, but shortly thereafter King Edward VII died and King George V came to the throne. He was told by a government minister that as a king he retained all his prerogatives. However, he could not use any of the royal prerogatives without the backing of a government minister. This ministerial advice has no basis in our constitution and amounts to a clear act of treason. Furthermore, it imagines the death of the king as a sovereign king. It is an act of high treason under the terms of the Treason Act 1351. How old is this castle? Is it? I think it's the 1280.
At least 600, 700 years.
It's a long. You can find out about that. Hereditary peerage. Meanwhile, Asquith travelled around the country telling everyone about the Lord's refusal of consent to the bill. He told the public this bill would give them a pension, but failed to mention the tax burden it would impose on them. In one fell swoop, Asquith had neutered the power of the Lords to protect the subject from bad law and remove the right of sovereigns to refuse the royal assent to parliamentary bills. This was in 1911. Asquith was a Fabian. Arguably, the undeclared policy of the Fabians was the destruction of the constitution and our way of life. Consequently, Asquith's actions amounted to a clear act of sedition, which at this level amounts to high treason. Subsequently, acts have continued to restrict the authority of the House of Lords. Finally, the plan to remove all but 92 hereditary peers was passed by Parliament in 1999. Currently, the government plans to remove all hereditary peers from the House of Lords. I don't know when this was written. Constitutionally, a peer can only be removed by a bill after committing a serious crime. A separate bill is required for each peer before he can be removed. It is unconstitutional and therefore illegal to remove every hereditary peer in a general bill. Baroness Ashton said in the House of Lords that a general bill cannot be used to remove the hereditary peers. Why do we want the hereditary peerage? Well, on the whole, they were honest and honourable. They had large estates and money, so they were most unlikely to take a bribe. They were also very protective of the family reputation. The hereditary peers are the traditional advisors to the sovereign. Her Majesty Queen Elizabeth II was taught constitutional law by a Fabian. Henry Marten and the Fabians, I believe, want to destroy our way of life. Her Majesty will always do what her ministers say she must. We are now governed by an elected dictatorship. What has this treacherous dictatorship illegally achieved? 1. Magna Carta and the Bill of Rights state that we cannot suffer any fine or forfeiture unless we have been found guilty of an offence in a court of law. Fines should not be excessive and no cruel or unusual punishments inflicted. We now have a whole range of fixed penalty fines for which we are not permitted to appeal in one of Her Majesty's courts of law. 2. The Bill of Rights says that any threat of a fine or forfeiture voids the offence. Yet we are told that if we drop litter or don't have a TV licence, we will be fined £1,000. We are told that if we do not insure or tax our car, it will be seized and crushed. 3. The Bill of Rights also states that we may not be imprisoned unless we've been found guilty of an offence in one of Her Majesty's courts of law. Yet now we have 28 days detention under the anti-terrorism laws. In other words, detention without any evidence being produced to anyone, let alone one of Her Majesty's courts of law. These constitutionally illegal laws are subverting the Constitution by the major crime of sedition, which at this level amounts to high treason against the Constitution and Her Majesty's subjects. Checking how long this is because our videos. How long is it?
It's been nearly 9 minutes so far.
9 minutes. Should we stop after this next bit?
Yeah.
Like number 4. So we're on 4. Edward Heath set up a conspiracy to subvert our ancient constitution. The major crime of sedition. Sedition at this level is high treason. Heath also conspired with others to hand over this country to a foreign power, the EU, the major crime of high treason. Every succeeding government has signed treaties with the EU surrendering our rights to govern ourselves under laws passed by the Queen in Parliament. This is where we are today. In doing so, every government since the Heath government has committed the major crime of high treason. Shall I just carry on for 15 minutes? The restrictions of the ability of the hereditary peerage to play their proper part in government as defined by the Constitution constitute the major crime of sedition, which at this level is high treason. 6. The removal of the hereditary peerage from the Lords constitutes an act of sedition amounting to high treason. 7. A minister from the Asquith government advised King George V that he keeps all his royal prerogatives, but he may not use them unless he has the backing of a minister. this is to usurp the royal prerogative, which is an act of high treason. It is a fundamental part of our constitution that Parliament may not surrender any of their rights to govern to a foreign power unless we have been defeated in war. It is a fundamental part of our constitution that a statute law cannot repeal, by implied repeal, a constitutional law. It is a fundamental part of our constitution that, when a law is against common right or reason or repugnant or impossible to perform, the common law will intercede it and strike it down. Parliament is governing outside the rule of the constitutional and common law of England and Wales. Scotland has its own constitution. This is what Albert says. I leave it to the people of Scotland to deal with government over breaches of the Scottish constitution. This is what Albert said, but I understand that Article 61 was invoked for the whole of the Commonwealth, and that some of the lords that invoked Article 61 were Scottish, and that the Act of Union transferred rights between Scotland and England, so we have a transference of all our rights. That's how I understand the Constitution. So although it has a different history, at some point it intertwined. I do not want you to take my word for any of this. My teacher at school used to tell us to look it up, because then you will remember it, and I am saying to you, looks it up. This is Albert talking. Legal codes of Alfred, the Charter of Liberties of Henry I, 1100, and the Magna Carta, 1215. The Petition of Rights, 1628, the Grand Remonstrance, 1641, and the Bill of Rights, 1689. Then I want you to look out of the window and see just how thoroughly the government is destroying the constitutional laws of England. Now you understand how our ancient constitution works. You have to choose whether you're going to roll over and become slaves, or live as free-born Englishmen like our forefathers, many of whom died to give us the rights and freedoms the world believes we enjoy. I am not asking you to risk death. We are not there yet, but nearly. But not there yet. I don't know when he wrote this. It could have been 10, 20 years ago. Maybe 10. I am asking you to fight back. England is ruled by law. Parliament is ignoring the best laws in the history of the world. Let us use the law to get back that which is ours, our constitution and our country. Sedition is any act designed to subvert the constitution. High treason is any act designed to betray the sovereign, constitution and people of England. Can you recognise these acts of betrayal by Parliament today? So it was quite a long chapter. We're next on the dispensing power of the King to dispense with a penalty for an offence. So that'll be a new chapter. Thank you for tuning in. We're with Common Law Assent. Be sure to look at our Facebook page if you're not on it. That's facebook.com/Common Law Assent. We'll put all the links below. This is part like 6 or 7 of this reading, and every single part we've gone somewhere different, and that's beautiful. So I don't want to fall down the cliff. I hope you've enjoyed it. Thanks for tuning in.